Chapter 6, Recording Number 2, Auten, Friday, August 30th, 1991, 11:27 a.m., Year 5, Day 14. Paradise Found? Again, I give humble thanks and appreciation to David Dodge and Alfred Adask for jobs well done. In 1789, the House of Representatives compiled a list of possible constitutional amendments, some of which would ultimately become your Bill of Rights. The House proposed 17. The Senate reduced the list to 12. During this process, Senator Tristram Dalton, Mass., proposed an amendment seeking to prohibit and provide a penalty for any American accepting a title of nobility, RG 46 records of the U.S. Senate. Although it wasn't passed, this was the first time a title of nobility amendment was proposed. 20 years later, in January 1810, Senator Reed proposed another title of nobility amendment, History of Congress, Proceedings of the Senate, page 529 to 530. On April 27, 1810, the Senate voted to pass this 13th Amendment by a vote of 26 to 1. The House resolved in the affirmative 87 to 3, and the following resolve was sent to the states for ratification. If any citizen of the United States shall accept, claim, receive, or retain any title of nobility or honor, or shall, without the consent of Congress, accept and retain any present, pension, office, or emolument of any kind whatever, from any emperor, king, prince, or foreign power, such person shall cease to be a citizen of the United States, and shall be incapable of holding any office of trust or profit under them, or either of them. The Constitution requires 3/4 of the states to ratify a proposed amendment before it may be added to the Constitution. When Congress proposed the title of nobility amendment in 1810, there were 17 states, 13 of which would have to ratify for the amendment to be adopted. According to the National Archives, the following is a list of the 12 states that ratified and their dates of ratification. Herein, please note that the 16th Income Tax Amendment was truly never ratified. But here you have one which was truly ratified with proof thereof, and it was secretly heisted from your Constitution. Are you getting a bit upset yet? Maryland, December 25th, 1810. Kentucky, January 31st, 1811. Ohio, January 31st, 1811. Delaware, February 2nd, 1811. Pennsylvania, February 6th, 1811. New Jersey, February 13th, 1811. Vermont, October 24th, 1811. Tennessee, November 21st, 1811. Georgia, December 13th, 1811. North Carolina, December 23rd, 1811. Massachusetts, February 27th, 1812. New Hampshire, December 10th, 1812. Now watch the now usual sleight of hand and footwork, for it has become the modus operandi when the going gets tight. Before the 13th state could ratify, the War of 1812 broke out with England. By the time the war ended in 1814, the British had burned the Capitol, the Library of Congress, and most of the records of the first 38 years of government. I'm sure the connection between the proposed title of nobility amendment, which would close England out of the U.S. government forever, and the War of 1812 becomes self-evident. You have entered massive wars for far less, like Desert Storm in Iraq. 4 years later, on December 31st, 1817, the House of Representatives resolved that President Monroe inquire into the status of this amendment, because all sorts of strange things were beginning to happen in your government. In a letter dated February 6, 1818, President Monroe reported to the House that Secretary of State Adams had written to the governors of Virginia, South Carolina, and Connecticut to tell them that the proposed amendment had been ratified by 12 states and rejected by 2, New York and Rhode Island, and asked the governors to notify him of their legislature's position. House Document Number 76. This and other letters written by the President and the Secretary of State during the month of February 1818 note only that the proposed amendment had not yet been ratified. However, these letters would later become crucial because, in the absence of additional information, they would be interpreted to mean that the amendment was never ratified. On February 28, 1818, Secretary of State Adams reported the rejection of the amendment by South Carolina, House Document Number 129. There are no further entries regarding the ratification of the 13th Amendment in the Journals of Congress. Whether Virginia ratified is neither confirmed nor denied. Likewise, a search through the executive papers of Governor Preston of Virginia does not reveal any correspondence from Secretary of State Adams. However, there is a journal entry in the Virginia House that the governor presented the House with an official letter and documents from Washington within a time frame that includes receipt of Adams' letter. Again, however, no evidence of ratification, none of denial. Whoopee! However, on March 10th, 1819, the Virginia legislature passed Act Number 280, Virginia Archives of Richmond, Miscellaneous File, page 299 for microfilm. Be it enacted by the General Assembly that there shall be published an edition of the laws of this Commonwealth, in which shall be contained the following matters, that is to say, the Constitution of the United States and the amendments thereto. This act was the specific legislated instructions on what was, by law, to be included in the republication, a special edition, of the Virginia Civil Code. The Virginia legislature had already agreed that all acts were to go into effect on the same day, the day that the Civil Code was to be republished. Therefore, the 13th Amendment's official date of ratification would be date of republication of the Virginia Civil Code, March 12, 1819. The delegates knew Virginia was the last of the 13 states that were necessary for the ratification of the 13th Amendment. They also knew there were powerful forces allied against this ratification, so they took extraordinary measures to make sure that it was published in sufficient quantity. 4,000 copies were ordered, almost triple their usual order, and instructed the printer to send a copy to President James Monroe, as well as James Madison and Thomas Jefferson. The printer, Thomas Ritchie, was bonded. He was required to be extremely accurate in his research and his printing, or he would forfeit his bond. In this fashion, Virginia announced the ratification by publication and dissemination of the 13th Amendment of the Constitution. Some argue that there is a question as to whether Virginia ever formally notified the Secretary of State that they had ratified this 13th Amendment. Some have argued that because such notification was not received, or at least not recorded, the amendment was therefore not legally ratified. However, printing by a legislature is prima facie evidence of ratification. Further, there is no constitutional requirement that the Secretary of State, or anyone else, be officially notified to complete the ratification process. The Constitution only requires that 3/4 of the states ratify for an amendment to be added to the Constitution. If 3/4 of the states ratify, the amendment is passed, period. The Constitution is otherwise silent on what procedure should be used to announce, confirm, or communicate the ratification of amendments. Knowing they were the last state necessary to ratify an amendment, the Virginians had every right to announce their own and the nation's ratification of the amendment by publishing it on a special edition of the Constitution, and so they did. Word of Virginia's 1819 ratification spread throughout the states, and both Rhode Island and Kentucky published the new amendment in 1822. Ohio first published in 1824. Maine ordered 10,000 copies of the Constitution, with the 13th Amendment to be printed for use in the schools in 1825, and again in 1831 for the census edition. Indiana Revised Laws of 1831 published the 13th article on page 20. Northwestern Territories published in 1833. Ohio published in 1831 and 1833. Then came the Wisconsin Territory in 1839. Iowa Territory in 1843. Ohio again in 1848. Kansas statutes in 1855, and Nebraska Territory 6 times in a row from 1855 to 1860. So far, Dodge has identified 11 different states or territories that printed the amendment in 20 separate publications over 41 years, and more editions, including this 13th Amendment, are sure to be discovered, for they are there waiting. So, you might be able to convince some of the people, or maybe even all of them, for a little while, that this 13th Amendment was never ratified. Maybe you can show them that the 10 legislatures which ordered it, published 18 times, consisted of ignorant politicians who don't know their amendments from their articles. You might even be able to convince the public that your forefathers never meant to outlaw public servants who pushed people around and accepted bribes or special favors to look the other way, maybe. But before you do, there's a lot of evidence to be explained. The amendment disappears. In 1829, the following note appears on page 23, volume 1 of the New York Revised Statutes. In the edition of the laws of the U.S. before referred to, there is an amendment printed as Article 13, prohibiting citizens from accepting titles of nobility or honor in presents, offices, etc. from foreign nations. But by a message of the President of the United States of the 4th of February, 1818, in answer to a resolution of the House of Representatives, it appears that this amendment had been ratified only by 12 states, and therefore had not been adopted. See Volume 4 of the printed papers of the first session of the 15th Congress, number 76, emphasis added. In 1854, a similar note appeared in the Oregon statutes. Both notes refer to the laws of the United States, first volume, page 73 and 74. It's not yet clear whether the 13th Amendment was published in Laws of the United States, first volume, prematurely by accident in an anticipation of Virginia's ratification, or as part of a plot to discredit the amendment by making it appear that only 12 states had ratified. Whether the Laws of the United States, Volume 1, carrying the 13th Amendment, was recalled or made up is unknown. In fact, it's not even clear that the specified volume was actually printed. The Law Library of the Library of Congress has no record of its existence. However, because the note's authors reported no further references to the 13th Amendment after the presidential letter of February 1818, they apparently assumed the ratification process had ended in failure at that time. If so, they neglected to seek information on the amendment after 1818, or at the state level, and therefore missed the evidence of Virginia's ratification. This opinion, assuming that the presidential letter on February 1818 was the last word on the amendment, has persisted to this day. In 1849, Virginia decided to revise the 1819 Civil Code of Virginia, which had continued the 13th Amendment for 30 years. It was at that time that one of the code's revisers, a lawyer named Patton, wrote to the Secretary of the Navy, William B. Preston, asking if this amendment had been ratified or appeared by mistake, a most interesting resource for information at any circumstance. Preston wrote to J.M. Clayton, the Secretary of State, who replied that this amendment was not ratified by a sufficient number of states. This conclusion was based on the information that Secretary of State J.Q. Adams had provided the House of Representatives in 1818 before Virginia's ratification in 1819. Funny thing, and take careful note, today the Congressional Research Service tells anyone asking about this 13th Amendment this same story, that only 12 states, not the requisite 13, had ratified. Skunks in the woodpile? Note, however, that despite Clayton's opinion, the amendment continued to be published in various states and territories for at least another 11 years. The last known publication was in Nebraska Territory in 1860. Once again, the 13th Amendment was caught in the riptides of American politics. South Carolina seceded from the Union in December of 1860, signaling the onset of the Civil War. In March 1861, President Abraham Lincoln was inaugurated. Later, in 1861, another proposed amendment, also numbered 13, was signed by President Lincoln. This was the only proposed amendment that was ever signed by a president. That resolve to amend read, Article 13. No amendment shall be made to the Constitution which will authorize or give to Congress the power to abolish or interfere with any state, with the domestic institutions thereof, including that of persons held to labor or service by the laws of said state. In other words, President Lincoln had signed a resolve that would have permitted slavery and upheld states' rights. Only one state, Illinois, ratified this proposed amendment before the Civil War broke out in 1861. In the tumult of 1865, the original 13th Amendment was finally removed from your Constitution. On January 31st, another 13th Amendment, which prohibited slavery in Section 1 and ended states' rights in Section 2, was proposed. On April 9th, the Civil War ended with General Lee's surrender. On April 14th, President Lincoln, who, in 1861, had signed the proposed amendment that would have allowed slavery and states' rights, was assassinated. On December 6th, the new 13th Amendment, loudly prohibiting slavery and quietly surrendering states' rights to the federal government, was ratified, replacing and effectively erasing the original 13th Amendment that had prohibited titles of nobility and honors. Wasn't that about as clever as you can get? Significance of removal. To create the present oligarchy, ruled by lawyers, which you now endure, the lawyers first had to remove the 13th Titles of Nobility Amendment that might otherwise have kept them in check. In fact, it was not until after the Civil War and after the disappearance of the 13th Amendment that the newly developing bar associations began working diligently to create a system wherein lawyers took on a title of privilege and nobility as esquires and received the honor of offices and positions, like district attorney or judge, that only lawyers may now hold. By virtue of these titles, honors, and special privileges, lawyers have assumed political and economic advantages over the majority of U.S. citizens. Through these privileges, they have nearly established a two-tiered citizenship in this nation where a majority may vote, but only a minority lawyers may run for political office. This two-tiered citizenship is clearly contrary to Americans' political interests, the nation's economic welfare, and the Constitution's egalitarian spirit. The significance of the 13th Amendment and its deletion from the Constitution is this. Since the amendment was never lawfully nullified, it is still in full force and effect and is the law of the land. If public support is awakened, this missing amendment would provide a legal basis to challenge many existing laws and court decisions previously made by lawyers who were unconstitutionally elected or appointed to their positions of power. It may even mean the removal of lawyers from your current government system. At the very least, This missing 13th Amendment demonstrates that 2 centuries ago, lawyers were recognized as enemies of the people and nation. Some things never change. Those who cannot recall history. In his farewell address, George Washington warned of change by usurpation, for though this, in one instance, may be the instrument of good, it is the customary weapon by which free governments are destroyed. In 1788, Thomas Jefferson proposed that you have a Declaration of Rights similar to Virginia's. 3 of his suggestions were freedom of commerce against monopolies, trial by jury in all cases, and no suspensions of the habeas corpus. No doubt Washington's warning and Jefferson's ideas were dismissed as redundant by those who knew the law. Who would have dreamed your legal system would become a monopoly against freedom when that was one of the primary causes for the rebellion against King George III? Yet, denial of trial by jury is now commonplace in your courts, and habeas corpus for crimes against the state suspended. By crimes against the state, I refer to political crimes, where there is no injured party and the corpus delicti evidence is equally imaginary. I had a document handed into Dharma's hands not 15 minutes ago from the Christic Institute entitled Avrgan versus Whole Update. It starts off, and I shall write just a tiny portion. Ruling disregards evidence, denies right to trial by jury. On June 18th, 3 judges of the 11th Circuit Appeals Court refused to reinstate Avrgan versus Whole, a civil racketeering lawsuit charged 29 members of a criminal racketeering enterprise with murder, destruction of property, drug trafficking, gun smuggling, money laundering, and other crimes. The judges upheld 2 decisions handed down by Judge James Lawrence King of Miami, an order granting summary judgments in favor of the defendants, and a subsequent ruling ordering the Christic Institute, General Counsel Daniel Sheehan, and plaintiffs Tony Avrgan and Martha Honey to pay more than $1 million in punitive fines for allegedly filing the lawsuit in bad faith. The Institute has asked all 11 judges of the appellate court to review the decision. If necessary, we plan to appeal to the Supreme Court. Just a bit more from this same case. Judge King's decision to halt proceedings shortly before the trial's scheduled opening date predicted on an argument unprecedented in law that plaintiffs are not entitled to their constitutional right to trial by jury unless they submit all of their evidence to the judge in admissible form before the trial begins. It goes on, but I haven't space here to handle that subject also. In other words, however, you have to have and prove each of the accusations to the judge before the lawsuit can be filed. Grounds for objection. A judge is prohibited from this conduct when a plaintiff has formally demanded a trial by jury. The authority to create monopolies was judge-made law by Supreme Court Justice John Marshall et al. During the early 1800s. Judges and lawyers granted to themselves the power to declare the acts of the people unconstitutional, waited until their decision was grandfathered, and then granted themselves a monopoly by creating the bar associations. Although Article 6 of the U.S. Constitution mandates that executive orders and treaties are binding upon the United States, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. The Supreme Court has held that the Bill of Rights is not binding upon the states, and thereby resurrected many of the complaints enumerated in the Declaration of Independence, exactly as Thomas Jefferson foresaw in Notes on the Senate of Virginia, Query 17, page 161, 1784. Our rulers will become corrupt, our people careless. The time for fixing every essential right on a legal basis is now, while our rulers are honest and ourselves united. From the conclusion of this war we shall be going downhill. It will not then be necessary to resort every moment to the people for support. They will be forgotten, therefore, and their rights disregarded. They will forget themselves, but in the sole faculty of making money, and will never think of uniting to effect a due respect for their rights. The shackles, therefore, which shall not be knocked off at the conclusion of this war, will remain on us long, will be made heavier and heavier, till our rights shall revive or expire in a convulsion. So you await the inevitable convulsion. Only two questions remain. Will you fight to revive your rights, or will you meekly submit as your last remaining rights expire, surrendered to the courts, and perhaps to a new world order? There was an addendum to this information which must be added. Documentation has been sent as to 5 more editions of statutes that include the Constitution and the missing 13th Amendment. These editions were printed by Ohio 1819, Connecticut, one of the states that voted against ratifying the amendment, 1835, Kansas, 1861, and the Colorado Territory, 1865 and 1867. These finds are important because, 1, they offer independent confirmation of these claims, and 2, they extend the known dates of publication from Nebraska, 1860, Dodge's most recent find and herein mentioned as such, to Colorado in 1867. The most intriguing discovery was the 1867 Colorado Territory edition, which includes both the missing 13th Amendment and the current 13th Amendment, freeing the slaves, on the same page. The current 13th Amendment is listed as the 14th Amendment in the 1867 Colorado edition. Now, in appreciation for this material, I ask reprinting of the following. This investigation has followed a labyrinth path that started with the questions about how our courts evolved from a temple of the Bill of Rights to the current Star Chamber, and whether this situation had anything to do with retiring Chief Justice Burger's warning that we were about to lose our Constitution. My 7-year investigation has been fruitful beyond belief. The information on the missing 13th Amendment is only a drop in the bucket of the information I have discovered. Still, the research continues, and by definition is never truly complete. If you will, please check your state's archives and libraries to review any copies of the Constitution printed prior to the Civil War, or any books containing prints of the Constitution before 1870. If you locate anything related to this project, we would appreciate hearing from you so we may properly fulfill this effort of research. Please send your comments or discoveries to David M. Dodge, P.O. Box 985, Taos, New Mexico, 87571. Please, you other researchers, like Patrick B., get on this and share up what you find. You will only turn this nation around through the law, and it is all there if you but uncover it and recover it. Salut. I have only one more tidbit to dump on you in the you are had category for this writing. In uncovering the mess with the conspiracy regarding Santa Barbara savings, RTC Bank of America fraud, and deceit involving Dharma and Oberle, it is uncovered that the following practice is common and takes place with the RTC in massive proportion these days. A bank, say Bank of America, buys from the RTC Santa Barbara savings, but they only get the good assets, and the RTC, you the people, carry all losses and contested property. In other words, it is completely prearranged that the bankers get all the assets and you take the debts. Good luck, world. Note that this property in question is already overshadowed by expenses against its value to 2 to 1 from litigation. But in the end, you the people will hold the bag. By the way, once again, There is found to be a deadline which is hidden from view, in which you must file an unknown form by a certain date, or you are forever barred from any claim. Is it not about time you do something about this fraud and plague upon your lands? I further wish to acknowledge a publication which I admire greatly, for it is dedicated to raising hell for lawyers. If you have a good story, please send it to them. We'll get around to it too. If you can write, if you've got a personal story about the legal system to tell, an essay to publish on injustice, or a letter to the editor, they want it. They can't pay you for it, but freedom is worthy of giving unity. The editor urges you to write and not pussyfoot around. Don't let the system scare you into silence. Name names. Send photocopies of relevant documents, pictures of yourself or the principal parties, and say what's in your heart as well as what's in your legal dictionary. They look for documents anywhere from letter size on up to 2,000-word essays. Well, ours is about 300,000 words, so guess it'll have to be in the shorthand. You can change these things if you want to, or you can sit and wait, and it won't matter anymore. These people call their publication Anti-Shyster, 9794 Forest Lane, Suite 159, Dallas, Texas, 75243. 1-800-477-5508. Their slogan: It's National Attorney Week, take a shyster to lunch. In the meanwhile, anyone wanting to write up this particular case in point, we will be delighted. We are most happy to give a whole bunch of names and places. You are going to find the same ones that continually pop up in the news: Bush, Reagan, Shea and Gold, Salomon Brothers, etc. The network is so massive that a clean sweep with your constitutional broom is all that will do it. God bless. Otten to clear.